Greetings to all. I am Reyneke in grade 11, representing the RCL from Lawson Brown High School.
Do you think school is preparing you for the future?
Yes, definitely. School isn't just about passing tests. Oral presentations have helped me gain confidence in public. Practicals give us real-life knowledge. Group tasks help us sharpen our teamwork skills. Even leadership roles like the RCR help us better prepare for decision-making and responsibility.
What is needed for your schooling to be more relevant and helpful for you to have the best chance of success?
Schools need focus sessions to guide the senior grades on how to apply for university and bursaries.
What do you think is the best way for teachers and principals to manage discipline in a way that's fair to everyone in a school? And if you could change one thing about how discipline is handled at your school, what would it be?
At my school, punishments like community service and wearing bibs does not seem to be effective. I believe suspending the learners from things that they love, such as sports or extramurals, would be more effective.
How should schools change or evolve to integrate technology and prepare learners for the workplace of the future?
Schools should replace outdated textbooks with tablets and teach how to navigate the online platforms to better prepare us for the modern job market.
How do you see the leadership roles of learners?
A learner leader represents the voice of the students. We don't just enforce rules, we create solutions. Leadership means listening, speaking up, and making sure that change includes every learner.
What is your understanding of the concept of discipline?
Discipline means choosing to do what's right even when no one is watching. It's about respect for yourself, others, and the future you want.
What needs to be done in schools to improve discipline?
Schools should take the initiative to arrange for weekly campaigns on respect and conflict resolution.
What role does relationships among staff and students play in addressing discipline issues in schools?
A good staff-student relationship helps uncover the real reason behind a learner's behavior. A learner could be struggling emotionally. You can't fix what you don't understand. Therefore, these relationships help us find the root.
What is the role of parents in addressing learner discipline?
Discipline starts at home. Parents should teach values, and they should also support the school rules and work with the teachers, not against them.
Stop.
The odds of winning the spin the wheel is getting better. Getting my horseman. So who feels like winning a bottle of wine or two? The excitement is overwhelming. Whoa! Now, where did my spin the wheel go? Someone closed spin the wheel. It cannot be. Who messed with my computer? Absolutely. No, I'm blaming a user because this was open a few minutes ago. And now it's closed. Let's see. Yeah, there we go. We have a birthday, but the birthday girl is not here yet. We can close the ads. If we could just have someone that knows how technology works. And first name for the morning. Drum roll. Sylvia. Sylvia. 3, 2, 1. No, Sylvia. It is empty. I'm Michael. I'm Andre, I believe. You. You can see that it's random. And as soon as they win, they don't get another chance. He's here. Red or white? White. White. It's a very nice white. The first person to win this morning. And the careful. Not here. Yo, there's more people not here. I thought you are the boss. Mr. Stone. I don't remember seeing them. Yes. Oh, I thought Ella was going to win. Ivana? Yo, this is going south. Okay, so who was the first speaker on the first morning? The Minister of Basic Education, and her name was? Give Carita a bottle of wine. Yeah. When will SAELA have its 30th year? Which what is it? Spoo said yesterday he's not winning, and now he's winning. And he's going to protest. We must get through a lot of wine. No, twice. You see, his name was duplicated because where's the mouse? That cannot be randomly twice. Aniki. Yeah. Soon there will be no one on the list. PM George. We must have more winners. This is not possible. Prof. JP. Aniki. Yes, 2 minutes te laat. Oh. Yeah. Prof JP, arme Annetjie. Iets dus. John. Red or white? Red or white? Philip. No way. Oh, Andre. Prof Andre. Okay, one more minute. One more minute. Red one. You got yours for the. She's forfeiting. Let's stick with the rules. If you win, you can't win again. You know that no one from Fetzes has won yet. No. Who's that? It's not there. Next year we must have a attendance list of the last morning. Nee, Gerard is sponsoring. Gerard is sponsoring. Okay, last one. You and I, are you ready for? We're waiting for our birthday girl and also not arrived yet. Jonathan. He's forfeiting. He's not forfeiting. He will pass it on to someone else. Huh? Oh, he's handing it over. Thank you. It's not a bribe. If you can drink and eat it today, it's not a bribe. That's what my opa said. I just want to close.
Good morning, ladies and gentlemen. You will see on the program for this morning's first session, it's titled the Hans Visser Memorial Session. Now, every year we have this special session on our program, and I'd just like to give a little bit of background as to what this session is about. So it is my honor to chair this session this morning. And as you all know, some of you might not know, SAELA was founded in 1996, and it arose out of the recognition that education law in a newly democratic South Africa would require careful and ongoing engagements. Now, SAELA has since served as a platform for collaboration between academics, officials, legal practitioners, school governing body organizations, all individuals who are committed to promoting sound legal frameworks in education and education law. Now, one of our founding members of SAELA was the late was actually Professor Hans Visser. And at the time of SAELA's establishment, he was actually a senior official at the Department of Education Law. Now, Mr. Hans Visser played a key role in laying the foundation for this specific association. He supported the early development and he advocated for centrality of legal integrity in education policy and governance. He was also known for his deep knowledge of administrative and education law and for his calm, principled leadership. Now, this session bears his name not only to commemorate his contributions, but also to remind us of the importance of continuity of growth and discipline. So the Hans Visser Memorial Session is traditionally devoted to examining the development of education law, looking at where we've come from, how the law has evolved, and where the most pressing questions of the future lies. Therefore, it's my privilege to welcome to the stage this morning our panel that will be contributing to this morning's session. As you will see, our first speaker this morning is Professor Reyneke. She needs no introduction. However, I would like to welcome you to the stage, Mariette. I've had the honor to work very closely with Mariette this last couple of years. I had the privilege of doing my doctorate degree under Mariette's leadership. And if you truly want to get to know someone, enroll for your doctorate degree with them as your study leader. Mariette, it's an honor to have you on the stage again, and we look forward to your session. Wow. Good morning, everyone. Thank you for being here, bright-eyed and bushy-tailed. Good to see all of you. We are looking forward towards the last part of our program. And yeah, good to see so many of you so early here. So this morning, I'm going to talk about school safety with reference to some of the latest cases and its implications for school governance. So what are we going to learn from these? There are a number of new cases. Thank you, Joanne. But I'm going to focus. I have 3 cases, but it might be too much. So let's see how far we get. So I chose from the cases that are available 2 topics: unsupervised learners and a few sport issues. So the first case is AM versus the Minister of Education in the Western Cape. And the facts of this case is briefly a grade 1 learner playing tag rugby with the other learners before school commenced. There was no supervision, and this particular boy knocked out the eye of another learner during this game. What is particular about this case is the facts surrounding this particular child. So it happened in around August. So this child was only in the school for 3 months. So he transferred from one school to another. In the 3 months that he's been in the school, remember it's a grade 1 learner, there was already 6 incidents reported of violence from this particular child. The head of discipline was not aware of all the incidents, and the parents, although they talked to the parents didn't want this child to get the medication that were prescribed to assist him with his behavior. So the questions that the court had to answer was, who's responsible for children before the school start? Is there a responsibility on the school? Was the injury that the child sustained reasonably foreseeable? And was the school negligent in leaving the children unattended? And then I'm going to talk about a few of my own interpretations. Joanna, you have to keep time. I didn't put on something, so and I'm just going to talk until the time is up. Okay. So the first question that the court had to answer: what is a school activity? And the department raised the defense that this incident is not covered by Section 61 of the Schools Act because Children playing before school on the school grounds does not constitute an official school activity. However, the court found that that is not the case because it falls under recreational and a social activity. And the essence of it is children are the responsibility of the teachers for the full duration of the time that the children are on the school premises, not class time. So from the beginning that they are there, and the court actually said that we have to look at the purpose of the children on the school. It is to attend school. Number two, the school opened the gates at 7 o'clock. That was the official time. Although it was not class time and official school time, the school activities already commenced with the teachers attending meetings, the foot patrol doing their thing, and the security people making sure that the children got onto the school premises. So, and then lastly, the in loco parentis responsibilities, where it says that parents have a legitimate expectation that if I drop my children off at the school, even if the school didn't start, that teachers will step in loco parentis. So that was kind of a weird angle that the department took, but the lesson is from the moment that the school starts, and then obviously also until the last child leaves the school premises, the school will be held liable. It's not at the end of the school day, but when they leave, that the school is responsible. Okay. So yeah, it was sanctioned activities. The children were allowed to play at it. It was a controlled exercise. A controlled environment, as I said, and the idea is not to leave all the children outside of the gate of the school. They must come in. And the court said that that argument of the department was actually irrational. And if the teachers claimed that the children knew they should not play rugby, it is, and they didn't do anything about it, they are still held liable. So then the question of was it negligent and was there negligence and foreseeable harm? So again, the standard of the diligence pater familias that we know. So who's that? That is a person who treads life pathways with moderation and prudent common sense. Okay, so for us, it's common sense. Of course, the children are of course, they are playing. We have to make sure that they are safe. And then the school knew about the fact that the boy was aggressive. It was well documented. And this incident was not an isolated incident. There was already, within 3 months, there was a pattern of bad behavior by this boy. So the court found that the school actually missed a lot of red flags. And the court said the red flags were there. It was clear that this is a problematic child. It was a red flag, the fact that his guardians didn't want to give the child medication or assistance. The reports indicated that this child easily explodes. His classmates were afraid of him, and the incidents in the past was also serious. So there's a very clear picture, although it is only 3 months, that this child has serious problems. And the court says it is clear that this child poses an inherent danger to the other children, and the court found that this child was a ticking time bomb. This is not my words. This is the words of the court. So the court found that the school was negligent because they failed to act in a clear way despite escalating warnings. And I think this is things that schools normally do. The school talked to the boy, and they engaged with the guardian, but no reasonable steps were taken. So there were no adequate control, despite the fact that the harm was foreseeable. The school supervision and monitoring of this particular child was inadequate. So it basically boils to some extent down to this. The court actually said this child should never have been left unsupervised on the school ground. So I almost get the idea the school had to make sure that this child is under constant supervision. And it was clear that this boy needed monitoring. So the court found that there was a failure. The school failed in talking to the previous school. This child transferred. They never looked at, when they saw things are not going well, they didn't talk to the previous school. The school did not insist on counseling. They asked the parents, please take your child to a doctor, please take your child to counseling, but the school didn't insist on it, and the school did not implement its own code of conduct. The court also said that school was negligent, and I think this is important, considering the realities that the department refused to expel learners. And in this regard, and this constant pressure on schools to fix the problem. So the school prioritized, the court said that the school was negligent when it prioritized the interest of this aggressive learner at the expense of the other learners. So where in the past we kind of saw in case law that there's always looking at the needs of the transgressing learner, that the court now explicitly say, but you overemphasize only the needs of this one group. And I think we will get to the point where we have to rethink what we do with and how do we balance the rights of all the children, and that simply saying we're not going to suspend this child because this child has a right to education. It brings us back, but what about the rights of the other children and their interest and their safety? And here already the court found that the department, not the department, but that the school was wrong. And it asks questions about how did this department support schools with children that we want to suspend or expel and we don't. And you guys know that I'm all in favor of everything else but suspension and expulsion. But sometimes things are just so bad that you need to make another plan with the child. So lessons from this case is there's a broad interpretation of what is school activities. Every case must be dealt on its own facts, and we have to rethink resource allocation for supervision, especially if early entry or late departure is permitted at the school. So what resources do we make available for children that are on the school premises before school starts and after the school start? I think one of the important lessons from this is do not normalize violence or accept aggressive behavior. And in this regard, the court said, equally, it can never be said that a learner who exhibits repetitive aggressive behavior, for instance, attacking other learners with a pair of scissors, throws books around in class, disturbing class, swearing at classmates, tackling other learners in class, hitting other children during breaks, throwing stones at the head of another learner, is exhibiting normal expected behavior for an average learner. It can thus never be successfully argued that such behavior blends with the circumstances of the school. So the school actually tried to argue, but the children in our school is kind of violent, and this is normal for our children. And the court said, this is not normal. This is not acceptable, and we cannot paint it as if it is normal. It also tells us that we should avoid institutional blind spots. So what are those? It is, well, the child is only 3 months in the school. It's only a grade 1 learner. This child has a right to education. Failure to protect the rights of the other learners and staff is a blind spot, I think. And there was a failure to inform the head of discipline of all the incidents. Now, this is kind of a difficult one because normally we say, teacher, you are responsible for the discipline in your class. You are the one that should control it. And the moment that the teacher asks, it seems as though she's not in control. She's not a good teacher. She cannot handle it. And on the other hand, if the teachers run with every discipline issue to the head of the department or discipline, will that person be able to deal with that? So where is the balance in that, in protecting the teacher, etc., but also making sure that the child receives the necessary help? There are inherent dangers in downplaying aggressive behavior. And I think when we are in a community where violence is normalized, we are at risk of downplaying the dangers of the aggressive behavior. There need to be central risk assessments of individual learners and groups of learners. And again, we have to rethink the role of our SBST. Is the SBST of this particular school functioning? Are we on the lookout for this type of behavior? So what is that role? And then does your school have mandatory intervention protocols for learners who have persistent aggressive behavior? So do we have specific things that we do for those children? So we have to translate our knowledge of risk into preventative measures. It's not enough to write the reports. It's not enough to contact the parents. It's not enough to talk to the child. We cannot wait for the parents to take action. But then the question is, so what should the school do? How far does this responsibility now move to the school, and what can the school do? Okay. Then we have to look at the rehabilitation and support for an individual learner, the duty to provide a safe environment to all the learners. We have to move from reaction to proaction. We cannot wait until the child knocked out another child. We see that this is a dangerous child. Even 3 months in this instance, the court said, you saw the red flags, you ignored it, it was there. And the school have to act independently and not only try to facilitate parental involvement to get help for the learner. So what the court actually said in that regard is, you talk to the parents, they didn't do anything. But you had a responsibility while the child was at school to either supervise him, get counseling, you have to do something. Now, to me, that is problematic. What does a school do without a counselor, without people there? There are lots of questions about, can the school, for instance, get medication for... You cannot. Where are those lines? And to me, the issue is, it is clear that the court is expanding the duty of care. And it's refining this duty of care, but is it practical? I think it's necessary, but is it practical? Does schools have the capacity to do that? And how do we assist schools in finding the parameters of this? To me, it seems as though this case says that the parameters of care and your duty of care is expanded. Okay, so we have to rethink the training of staff, the provisioning of social services in schools, about teaching our children conflict resolution skills, not only maths, soft skills as well. The need to rethink our approaches to discipline and strategies to improve parental involvement. So I think this case in itself leaves a lot of room for us to discuss, but I'm quickly going to... How much time do I have 5 minutes left. So Baku's case is also about an unsupervised child. They were left unattended for a last period of a day when one child, he tried to intervene when there was a fight and he was stabbed to death. This school is known for drugs and weapons on the school grounds. And the question again, was this foreseeable? Was the school negligent? And the court said it's not necessary to supervise children all the time, but the level of supervision depends on the context of a particular school and child. Okay, and I'm going to contrast this case with another one. Was the harm foreseeable in this particular school? Yes, because they knew there were drugs. They knew there were weapons at the school. The teachers were afraid, the other children were afraid, yet there was no frequent searches. And there was another stabbing 10 years ago. And since then, they had one search at the school. And the court said, but we don't expect you to do searches every day. It depends again on the circumstances, but you have to do what is reasonable pertaining to searches and seizures within the context of your particular school. And then an interesting thing is here, the court says, MEC, you know, part of the problem here is the fact that this is an overcrowded school. You should have foreseen that in an overcrowded school, this is a problem. So the court actually directly says that the failure of the MSc to provide schools contributed to the foreseeability and the eventual happening of this. So I'm not sure what we're going to do with that, but it is out there. And again, the parameters of care, in my view, it seems as though the courts are expanding it, and we need to be alert to that. Then on the other hand, the Gora case, this is an older case, but in this case also children left unattended. But in this particular case, it was unprecedented. It was a well-disciplined school. There was no violence in the past, and the school said, or the court said that in the circumstances, considering everything and the particular learners involved, it was not foreseeable. So in general, to conclude this part, it is about not normalizing drugs, violence, and things at school. We have to ensure that it's a safe environment. We have to be cautious of the realities of the communities. We have to look at the behavior of individual aggressive learners and the group. And we have to do regular risk assessments of our schools. How violent is it? Who's the violent children in our school? And we have to provide counseling. Do I have a minute for a last case? You do? Okay. So then another case, it is the Stone versus Ivanisevic case. This was about a water polo game, and in the game, one player hit another player with a fist and caused serious damages. So the court case was mostly about the individual player, whether the other individual player was responsible. And eventually the court found that the individual player was indeed responsible because the other player did not consent to someone playing outside of the rules and acting in that manner. And that is in line with the previous case where a rugby player's neck was broken and the same argument was. But I know there are risks involved in this game, but I do not give consent to be hit or scrummed in an unlawful way. But then the plaintiff actually went further. And that was the important thing of this case is it actually argued, the player argued that the school, both schools actually was negligent in playing a player, allowing him to play when they knew that he was aggressive. And how many times does that work in our schools? We know this is a player with a short fuse. It is about, another question was about the coaches actually hyping up learners. And does that lead to injuries? And then the role of the crowd. This is, those typical derbies, there's two schools that's our rivals forever. And this is the highlight of the sporting career. And the court didn't eventually, some of these claims were left, and some the court said there was not enough evidence to find against the school. But this is my questions is, and I'm just going to leave it at that, is coaches, what are you doing? Are you, and basically what the court says, you have a responsibility towards both teams. When should a referee stop a game? When the players are aggressive? When there's a fight, should you stop the game at the first instance? When the crowd is taunting specific learners, what should we do? Should we stop that game? So although there was in this particular case not enough evidence to hold the school liable, I think it opens the door for people to say, but you are hyping up the children, the crowds are creating an environment where children will act irresponsibly and beyond the scope of the rules of the game. And so in this instance also the court said, the fact that there was proper record keeping, etc., helped the school to prove that they were not negligent. And the disciplinary, although this was an aggressive player, there was no discipline record against him. But again, how often is our star players not those most aggressive, volatile learners in our group? So thank you for that.
Thank you very much, Mariette. I think we'll take questions at the end of each presenter session. I would now like to invite to the stage Mr. George Oupa Moroasui. I've known George for quite a couple of years now. I have the privilege to work with George at FETSAS. I think those of you that know George well would know he's always very smartly dressed. Is one of the individuals that speaks 6 languages. George, if I'm not mistaken, 9 languages. Oh, I'm sorry for that. But George, welcome to the stage. So it's an honor to have you, and we look forward to your session.
Thank you. Morning, colleagues. It's always a pleasure to be here. Don't have much time today, but I would like us to talk a little bit. My topic says evolution, ensuring legal responsibility in SGB employment practices. I want to go a little beyond that. Mariette, I had to change this topic 100 times, and it gave me sleepless nights because considering if one is to talk after Mariette, good luck. So last night I didn't sleep that well. The reason I chose this topic was out of worry more than anything else. It's difficult to speak to the converted Ibrahim. It's a bit difficult to talk to the converted, and maybe many of us seated here are not or may not be affected by this, but you know many who are. And I'm going to talk about employment out of compassion. and the mistakes that we are more likely to commit as the SGB. So we're saying ensuring legal responsibility in SGB employment practice. The topic says evolution. We look at it as a futuristic or a technology thing or pedagogy or a digital thing, yet not. And we say real evolution begin where the school gates open. So I want to talk more to everyone else, but more to the SGBs in their capacity as the employer. And this is where people get employed. Unfortunately, the reason why I had to pick this topic is because we came across between February and June about 3 cases so far in the Free State where schools have been fined in excess of 100,000. Different schools. All 3 are in Thabo Mofokeng district. And they've been fined by the Department of Employment and Labor. What did they do wrong? And all of them, when you speak to them, they say, we were just being compassionate. Sarah, you've been volunteering with us for the past 3 years. We've been giving you a stipend of 1,000 rand. We are able to raise funds. Can we pay you 3,000 rand? It is okay, thank you. Went on for many years, and Sarah had to retire. On retirement, she goes to the Department of Labor and says, I did not get a blue card, UIF. Okay, eyes wide open, you get a visit by an inspector. Can we have the employment records you don't even have? 1. 2, was she registered? No, she wasn't. 3, how much were you paying her? No, we were giving her 3,000 rand a month. 1, are you aware that you've been paying her below the minimum wage, as in this year, 2025? No, but we were just doing this out of compassion. The school doesn't have money. Are you aware that you should have registered her with the UIF? No, we couldn't make a deduction because when we deduct, she's going to get even less. Are you aware that you should have made deductions in terms of the Compensation for Occupational Injuries and Diseases Act? No, because out of compassion, she would have received less. So we're just giving her the 3,000 rand per month as is. Okay, may we have the pay slips? No, we don't have. We're just paying her via or through an envelope. I don't know how, but yeah, that is the status quo right now. Some of the schools are sitting with fines in excess of 144,000 rand. Now, who's going to pay that? Compassion. Schools meant well. Unfortunately, meaning too well doesn't mean the law has to be broken. Therefore, unfortunately, compassion became negligent. Now, sitting with a fine, I am a quintile 1, 2, 3 school. I don't even have that money. Where do I get it? Who's going to be held liable for that? Oh, no problem. We've got Section 60 of the South African Schools Act that says, no, I was acting diligently and therefore I am protected. What do you say about ignorance of the law? Already you have broken how many pieces of legislation and their regulations? 3. You didn't register the employee. There's no UIF. There is no COEDA deductions. You've been paying below the national minimum wage. Hence, the fines are big. Okay, we managed to work one out and we realized that the inspectors were wrong in their calculation. So one is out, we still have two. I don't know how we're going to work around that one. I am simply saying that it can happen to anyone. It is happening. Many schools have or are acting out of compassion, yet breaking the law. It is going to get ugly. As I said, some SGBs believe we are too small, but we want to accommodate, but to their detriment. So this is a practice we need to do away with and accept the circumstances as they are, to say, if we can't afford, what should we do? We cannot afford, but we want to accommodate this person. I've already talked about section 60, which says that, which I will read, and it says, section 60, subsection 1A, the state is liable for any damage or loss caused as a result of any act or omission in connection with any school activity. I want you to underline school activity because I want us to define it. And B says the state is not liable for any damage or loss caused as a result of any act or omission, underline act or omission, in connection with any activity that is not a school activity conducted by a public school. It says, however, good faith is not the same as carelessness. I meant well. I wanted to. But then what we say about the phrase ignorance of the law is no excuse. I'm trying to marry the two. So ignoring the law such as the COIDA, the National Minimum Wage, the UI Act is or can be seen as gross negligence. Because you meant well, you were trying to accommodate. You just wanted her to get all her salary. So I'm simply saying to SGBs as employers to say, we need to be very careful when coming to this. I know we meant well. I know we didn't have money. Now that we don't have money, what should we do? I think I skipped this. Okay, allow me to talk once more, just your section 60 protection. I'm saying, let me talk of vetting, another mistake that many schools do. When SGBs employ without the checks, negligence starts before day one. We have advertised, we received applications, we shortlisted, we want to employ George. Have we vetted? If we fail to vet, are the consequences therefore? So legal responsibility of the school governing body doesn't begin on the first day. It begins the moment you as the SGB consider hiring someone, and that means that vetting must be your first legal action and not an afterthought. When I'm already there employed, you're saying, okay, now let us vet. Good luck. This is what happened in the case of Swanepoel versus the Minister of Education. But in this instance, for those who know the case well, it was just an oversight on the part of the Western Cape Education Department, in that they employed Mr. Swanepoel, Z83, have you been convicted of an offense? Mr. Swanepoel answered no. He worked for a number of years and later he applied for a promotional post to principal. Z83, have you been convicted of a criminal offense? No. He was employed as a principal of a farm school, and later in 2020, Mr. Swanepoel decided to rape a grade. Standard 3, grade 5 learner. The family sued the Western Cape Education Department and said, but you endangered our child. I testified in the case because they said, the department said, no, SAES should have done it, should have vetted. But the act says, employer, you must. Therefore, on that basis, the employer lost, the employer had to pay. Suppose it were an SGB as the employer. Where do we get the money? So I'm simply saying it can happen to any one of us as the SGB. So we need to be very careful and very intentional when it comes to these things. Sometimes we take them for granted. So it shouldn't be a negotiable, it shouldn't be something we should be fighting over when the time comes, when it's appointment time. These are things that we need to put in place. The systems are already there. Okay, some schools choose not to, but these systems are there. We just have to do it and be very intentional about it. And stop fighting about, we want that one. Please do that. Because what does it mean for the SGB? Now that you are being sued as the SGB, where are you going to get the money? And two, will you be able to hide behind Section 60? No, you cannot. Because you were grossly negligent. You failed to do that which you should have done. So please ensure that you do vet your employees in this regard. So what should schools be doing going forward? I've already said, one, please ensure that you comply with these acts, the COIDA, the UIF, and the national minimum wage. Please, no matter how compassionate, get the employees to understand that this is a duty, because they are the very first ones who will be running there and say, I don't have a blue card. Even if they knew, they agreed. You cannot agree, of course, to break the law, but it will be fitting of me, it will suit me to go up there and say, no, it didn't, I'm not getting it. And the truth is, it will not be there. Am I going to hide and say, Section 60, come and protect me, meaning MEC, come and protect me when I was grossly negligent? Please make the necessary deduction. So they need to understand that even if it's 3,000 rand, I must deduct. I feel for you, but I must. Or if we cannot afford, you can apply for exemptions. You can apply for exemption, and as we know or may not know, some of us, this is well regulated. Before you make the first payment, you must have applied in terms of Regulation 5 of the National Minimum Wage, an exemption. Once granted, only once granted, may you begin to make the payment. You cannot make the payment in reverse. You cannot start paying and then apply for exemption. And that exemption is valid only for a period of 12 months, meaning every other year, or as and when the 12 months expire, you need to apply, and you need to show that we don't really have the funds as the school. So it is just but a plea to say, let us do the right thing. The law is clear. There is no way around it, but there are provisions to say you can apply for this exemption. It is doable, and let's assist our schools, at the same time protecting ourselves as the SGB. As I said, where you are grossly negligent, unfortunately, you cannot claim favor or refuge under Section 60 of the South African Schools Act. I thank you.
you for that, George, Opa. We really enjoyed your presentation. I'm going to ask our next two presenters to please come and join me here on stage. The two speakers are Matteo Nkosi and Zama Madondo. They're both from ISASA. They're both admitted attorneys. Matteo, if I'm not mistaken, you joined ISASA in 2023 and your colleague in 2024. I've also noted your colleague has enrolled for her master's degree. So, sokkies optrek, mister. You have to explore those avenues as well. But we're looking forward to your session this morning, and the stage is yours.
Good morning, colleagues. So my name is Matteo Nkosi, and I'm joined today here by my colleague, Ms. Zama Madondo. We are from the Independent Schools Association of Southern Africa. We represent about 900 independent schools in the region of Southern Africa, so it's a pleasure and it's a, we're pleased actually to be here. So today we're going to be discussing scholarship and admission practices in independent schools. And this doesn't just relate to the independent school sector. It also applies to the public school sector, specifically schools that attract sporting talent. We're talking about schools that have big rugby teams and big rugby tournaments. This is particularly the big boys schools in the public school sector. And just to give context to our presentation, I won't be using any names, I won't be naming any schools, but it often happens in the independent school sector that schools that are in a specific area, let's say Johannesburg, for example, you would have schools that would approach another school, let's say school A would approach school B to say that your school is attracting a lot of our learners, or rather you're poaching a lot of our rugby talent, and we would like for that to stop. Because as we all know, South Africa is a sporting country, and that also translates into schools being sport focused and emphasizing sports, specifically rugby. So what would happen in these schools is that one school would say that if you don't stop offering scholarships and bursaries to my learners, then we'll make sure that your teams don't have anyone to play with. So essentially what's going to happen is that your school is going to be isolated, and effectively it means that your team won't have anyone to play against. So now we're just going to be discussing the admissions and the scholarship criteria that should be applied in terms of our legislation in South Africa. And just very briefly, we're going to be looking at the South African Constitution, of course, POPIA, the South African Schools Act, and the Competition Act. So as we all know, South African schools, including independent schools, do not operate in a legal vacuum. Their admissions and scholarship criteria are subject to complex legal frameworks, which includes the Constitution, equality law, data protection legislation, and the Competition Act. So today, during our discussion, we're just going to be focused on the Constitution, of course, specifically Section 9 and Section 28.2, which speaks on the rights of the child. We'll also be looking at POPIA, the Protection of Personal Information Act, and the Competition Act. The Constitution, or rather Section 9 of the Constitution, focuses on the right to equality. And this prohibits the state and any other person from unfairly discriminating directly or indirectly against any person. And this may not be on the basis of race, gender, sex, or ethnic or social origin, religions, conscience, belief, culture, or language. And while the Constitution provides strict prohibition against unfair discrimination, on the prohibited grounds of, it recognizes that the This discrimination can be established to be fair. For example, the admission policy of a faith-based school can be seen to be fair if it does exclude learners who are not part of that religion. That's just one example of that. And the Constitution goes further to say that the rights of the children are paramount in any decision that has to be made regarding a child. So this also applies to admission criteria that's applied to a school. And importantly, we have to remember that the rights of the child are paramount in any decision that has to be made regarding that child. Next, we're just going to be looking briefly at PEPUDA, which is the Promotion of Equality and Prevention of Unfair Discrimination Act. And this act, I'm just going to focus importantly on the illustrative list of unfair practices that applies to certain sectors. And in the education sector, the prohibited unfair practices include unfairly excluding learners from educational institutions, including learners with special needs. The next one would be unfairly withholding scholarships, bursaries, or any other form of assistance for learners of particular groups identified by the prohibited grounds. So this, I'm just going to quickly link it back to what we had discussed, or the matter we had discussed earlier that happens with schools. So again, the Constitution and specifically PEPUDA prohibits anyone, including schools and people that make these decisions within the school community, from prohibiting or withholding bursaries on arbitrary grounds. So you cannot withhold a scholarship for a learner on the basis that it's going to interfere with the relationship that I have with the next school. You want to ensure that every decision that you make that involves a child takes the essence of Section 28(2), which provides that every decision has to be in the best interest of the child. Additionally, PEPUDA allows complaints in respect of contravention of the Act to be lodged with the Equality Court and proceedings held to determine whether the discrimination is fair or unfair. So unfortunately, at this stage, these principles have not been applied because no parent has actually sent a school to the Equality Court to say my child was prevented from getting a scholarship at a certain school because the schools have colluded or they've entered into an agreement amongst themselves. But we do think that in the near future, these things will be raised because it's a burning issue amongst independent schools, and particularly in the public school sector, it's an issue specifically around the schools that have big rugby teams. According to the Schools Act, it is also accepted again that the scholarship program of a school must be considered to be part of the school's admissions criteria, which then also means that it has to be aligned with Section 29(1) of the Constitution and the South African Schools Act itself. In terms of Section 5(1) of the Schools Act, a public school must admit learners and serve their educational requirements without unfairly discriminating in any way. So again, going back to the story that I just told at the beginning, to withhold a scholarship or a bursary for a child based on these arbitrary grounds would be considered unfair discrimination. Because normally when scholarships are awarded to children, it's normally to children that are from impoverished communities, because you want to upskill that learner, you want to train them to become the best possible rugby player, netball player, or hockey player that they could be. And lastly, I'm just going to be looking at POPI. And POPI states specifically Section 34. 34 of POPI states that anyone or everyone is prohibited from processing the information of a child, or of children rather. Section 35(1) further states that this prohibition does not apply if such processing is carried out with the prior consent of a competent person, B, necessary for the establishment, exercise, or defense of a right or obligation in law, and D, for historical, statistical, or research purposes to the extent that that purpose serves a public interest. And then number 2, to the extent that it appears to be impossible or would involve a disproportionate effort to ask for consent from the sufficient guarantees are provided to ensure that the processing does not adversely affect the child. So again, importantly here, Poppy also reinforces this concept that you may not disclose any information belonging to a child. And the reason we brought up Poppy is that a lot of the times these schools would also insist that if you receive an application for a scholarship, or if any of my learners who are in the rugby A team, if any of them apply for a scholarship at your school, you must immediately inform me so that I can try and compete with the offer that has been made. And again, this is also going to adversely affect the child because the child is going to lose out on an opportunity at a better school or at a school that has better facilities for training for rugby or any other sporting program. So my colleague Zama is going to speak on the Competition Act and how it applies in these circumstances.
Yeah. Thank you. Okay, I think everyone can hear me. Good morning, colleagues. I will be taking you through the Competition Act and its impact, the foreign case law, as well as what's the best way forward. So a key consideration, can you see? Sorry. Okay. So a key consideration amongst competition regulators across the globe is the type of information that's shared amongst competitors. So in this instance, competitors would be the different schools with the different programs that come together and share commercially sensitive information. So in this instance, commercially sensitive information would be maybe the identities of the learners that are applying for admissions and scholarships. And the problem with sharing that information is then competitors, which are the schools in this instance, can implement, monitor, or enforce a cartel. So, for example, think of the bread cartel scandal a few years ago, something similar, or they can collude anti-competitively. Now, as my colleague has said, at this point in South Africa, we haven't really tested these provisions in the education sector because this issue hasn't gone to the Competition Commission yet. But we do anticipate that it's a growing trend among schools. So this matter could be brought to the competition authorities for adjudication. The central question then becomes the horizontal provisions of the Competition Act and whether the provisions in question may be seen as excluding competition between schools attracting sporting talent. So a horizontal relationship, for example, would be schools in the same region. So my colleague used Johannesburg as an example. So all schools in Johannesburg coming together and saying, we have this gentleman's agreement and we are going to, in effect, this agreement will lessen or dampen competition. So in the market, so we're going to come together and we're going to say, we are not going to poach each other's students, or if a student applies for a scholarship at my school, I will then discuss it with my colleague, or if a student applies for admission at my school, I'll then discuss it with my colleague at the school where we have this agreement. So disadvantaging the markets in that case, which are the students. So in terms of Section 4, subsection 1 of the Competition Act, this agreement could be prohibited because, like I said, it is a collusive practice and it could form a cartel. Now, South Africa hasn't really tested this yet, so we have looked to foreign case law to kind of see what other comparative jurisdictions are doing, which we have started with the United Kingdom because they tend to have a comparative jurisdiction and how they function. I'm just going to take you through 3 cases, one in the UK, one in the US, and 2 in the US. So in 2006, the United Kingdom Office of Fair Trading, the OFT, found that 50 independent schools had infringed the prohibition imposed by the United Kingdom competition authorities by participating in an agreement and a concerted practice which prevented and restricted and distorted competition in the education market. So what these schools were doing is they'd come together and they would agree on exchanging specific information in relation to pricing, fee increases, and that would essentially fix the market. So, for example, school A would say, we're going to increase by 5%. So, school B also increases by 5%, and they'd like average fees, which is anti-competitive behavior because it lessened the choices that consumers had. So, kind of fixing the market prices. And the OFT found that this arrangement obviously constituted a restriction of competition because, like I said, it distorted the market. But so, despite the overwhelming evidence against them, they managed to get into a settlement agreement. So, the sanction against these schools wasn't as overwhelming as it could have been. The second case is in the United States of America, where it was an issue with college athletes and their remuneration and benefits and compensation. So the National Collegiate Athletics Association restricted compensation and benefits, and they were taken on a class action suit by college athletes to say there were anti-competitive effects in their practices. And they sort of restricted these students from obtaining remuneration and compensation benefits that they would have had the market not been fixed. The last case is the Ivy League schools case. So what they would do here is they'd fix admissions and financial aid in a way. So they'd come up together and say, Zama has applied to Harvard and Stanford, for example. And then they would sort of average the amount of financial aid you would get. So the students would be disadvantaged because they wouldn't get the maximum financial aid they would have gotten had they just applied to all these schools, and these schools weren't coming together and discussing and sharing information of these learners to fix the sort of financial aid that they get. How is that anti-competitive? It was anti-competitive in the sense that students didn't get, one, the maximum financial aid, but two, the options for schools to go to were limited because they were getting sort of fixed offers across the schools that they'd applied to, as opposed to just applying without managing things in the background because of a gentleman's agreement. So, what are the implications of the legislation we've discussed on how schools should be handling scholarships and admission practices? So, in terms of the Constitution, when we look at these admission and scholarship policies from that point of view, you can't discriminate unfairly against a child. So, you need to ensure that when you're making these decisions, it's not anti-competitive or trying to manage relationships, but it's in the best interest of the child. PAPUDA gives effect to Section 9, so you need to make sure that there are no discriminatory practices and that everything you do is legally justifiable. PAPIA limits the exchange of information between parties, especially information relating to minors, so you must ensure that when you're sharing this information in the background, which is often what happens in these instances, the people have consented to the processing of their raw data and of the discussion amongst the different schools. And then the Competition Act, like I've discussed quite lengthily, you can't enter into collusive agreements amongst each other as schools, limiting the options that learners have in getting these scholarships. Foreign case law is persuasive in South Africa, so we use it as a guiding light. It's not binding, but we can see from the foreign case law discussed that gentlemen's agreements can be found to fall foul of the Competition Act in South Africa, and that it could attract penalties and punitive actions against schools. So I think the overall, just going to go to the conclusion. The overall idea of this discussion is that we need to promote transparency in our policies. They need to be legally compliant and they need to be designed to serve the best interests of every learner without undermining access to open and inclusive education. And that is the end. Thank you.
Thank you very much to Zama and Matteo. If I can ask our panel members to quickly join us on stage for one round of questions. Mariette, whilst you join us, we have a first online question for you. So I'm just going to read it out loud for you and then just ask for hands in the audience. Mariette, the question is, I would just like clarity on what Prof. Mariette said regarding staff on duty until the last child has left the school grounds. Does this mean that even if the school ends at 2 p.m. and extra meals end at 4 p.m., staff are expected to remain with learners, even if it means until 8 p.m. at night? Parents don't answer phones and no way of getting hold of someone to come pick up the child, or is there something else that can be done? So what do you think on that, Mariette? I'm going to ask for hands in the audience. Number 1, number 2, Ibrahim, Tilla, number 3, number 4, and the last question, number 5. Thank you very much.
Thank you very much Thank you for all your presentations. It was very informative. My first question goes to Mr. Nkosi. I would just like you to elaborate a little bit on what you mean when you say the scholarship policy should be aligned with the school's admission policy, especially if you're talking about a public school. And then Ms. Madondo, thank you very much. I'm wondering what you think about if I were to make a statement to say bursaries in general for children are a little bit, what's mensenhandeling? Human trafficking. Am I being a bit over dramatic when I'm saying that? And then, yeah, there's too many questions, so I'll close them down. Thank you.
Thank you for that presentations. My question is for Mariette. One of the Is that better? Okay. Good morning, everyone. My question is for Mariette. One of the things that was not listed in the institutional blind spots was the CS policy, which is the screening, identification, and assessment policy. And I'm wondering whether in any of the court cases, particularly where aggression was identified as something that a lot of the learners were struggling with, whether or not the courts actually explored the use of the CS policy, because the CS policy requires that at least at a classroom level, the teacher must identify barriers to learning, and behavioral difficulties is one of those barriers to learning. The individual support plan must be developed, must be revised or reviewed every term. So has the court or any of the parties raised that?
Good morning. This question is for you, Mariette. In terms of schools, all schools have an official start time and end time. And my question is, where does the school official duty stop and parent neglect come in? Because all parents are informed that school ends at a particular time and they have 15 minutes to actually pick up the kids. But we find from school's perspective that we're sitting there till 5, 6 o'clock, basically babysitting the child, and that's where they get up to mischief. So does that not tantamount to parental neglect? Thank you.
Thank you again. Prof, just to check did I hear you to be saying it is the school's responsibility to rehabilitate the child? If you could just clarify that, George. In vetting, is it meant for all positions or only high-level positions, or the positions that are deemed to be sensitive? And the last one is in terms of the vetting process itself. When does it happen? Immediately after the SGB shall have appointed, before the person is involved? I want to believe so, but just for you to clarify that. Thank you very much.
Um, I actually also want to ask what you asked, but maybe I should just also ask if we consider that many schools these days use coaches from outside, and other people coming in and out, are they also supposed to be vetted? But I think you asked that. And then also on the SGB, before they are selected or elected, are they also vetted? And what happens? And if not, if it's after elections, are they really vetted? Yeah.
Thank you. I'm going to start here on my left-hand side with let's hand over to Prof. Reyneke first. Okay, so the question, I think question 1 and 3 is very aligned. So the question is, how long should the school look after the child after the school bell rang? So the fact of the matter is, the school didn't, or the court didn't say that all the staff should be there all the time. I've also been working on a number of other cases where, for instance, the court found that 2 staff members on duty walking around was enough. I think in the end that might become a problem because 2 staff members in a school of 400 children might be enough, but in a school of 1,500 children, 2 teachers will not be adequate. So again, I think it is back to the idea of risk assessment. What is your context? How many children? Are they very young? Are they old? Is it a violent environment, etc.? For how many staff should be there before school and after school? But the fact of the matter is, as your extracurricular activities, etc., is included in your school activity definition. So the law doesn't make a stipulation and say your in loco parentis responsibilities end 30 minutes after the activity stops. You are in loco parentis in the place of the parent until the parent is there. That is my interpretation of it. So I think it is management type of thing, and I think a school will be in so much trouble if you just leave a child there on the pavement, or even in the school grounds and say it's 6 o'clock, we are knocking off, and the child get raped or trafficked or something. So I think it is about also then instilling other measures against staff, against or with parents, to rather look for, I don't have an answer for you on how do you manage it, because it is people that you have to manage. So would it be okay to say, okay, if your parents don't pick you up 30 minutes after the activity, you are not allowed to play in the next game? I mean, now we punish the child for the parents' behavior. So what effective measures are there? Are we not just back to a societal issue of bad manners and entitlement, and you have to do it? So it is, I think, to a large extent about also trying to work on the culture of a school and respect in a school. But from a legal point of view, I don't think there's anything else you can do but to look after that child. I wouldn't take the chance of leaving the child unattended. The level of supervision depends on the circumstances. So Ibrahim asked about the SIAS. I didn't come across it in any of the cases that the court argued for, but what did you do about SIAS? It was not in any of the arguments of any of the parties, and that is why I asked the question about, do we do enough to train our SPSTs? Do they know what the SIAS policy does and how it should function? And then again, an issue back to
departmental responsibilities to say, okay, we did the assessment, our SPST find this child very aggressive, and then you wait 2 months for someone from a district office to say, but there's no blood, so there's no harm now. We until there's no blood, if there's no blood, we cannot come because there are other pressing matters. So it is again a matter of capacity in my view on when are we getting enough support from the district officers. I mean, and in this instance, it was 3 months for a grade 1 learner, and the school was held liable, eventually the department. But we don't have time on our hands. So SPSTs and the use of the CIAS policy must be streamlined and implemented. Again, the idea of parental neglect. Well, while we talk about that, questions that we should ask ourselves is, do we know Section 150 of the Children's Act adequately to actually ask the question, if a parent consistently leaves a child at school, does that not indicate that that child is in need of care and support? Isn't it then the responsibility of the school to contact a welfare organization with statutory powers to investigate? Why is this child always not picked up? And I know about a case where it eventually transpired the mom was on drugs and alcohol. So she just left the children at school, or the children didn't go to school because mom was under the influence to go. So in those type of instances, you might ask yourself, should there not be an investigation regarding, is this child in need of care and protection, to get, well, maybe it might be just a wake-up call for parents to say when the social workers knock on your door and say, yeah. Yes, the way I understand the first case, it seems as though the court actually says schools have to play a much more active role in providing support for the child. It doesn't say exactly counseling, but you get the idea that there must be counseling for this child, that the school must provide it, and that is in line with the Jacobs case as well, where the court said that the school and the counsel, and in that case, it was that counseling provided by the school was inadequate. So, yes, the way I understand it is the court says you cannot just leave it up to the parents to decide if and when they want to give counseling. You either have to look after that child and make sure he doesn't harm other children, and then you have to provide rehabilitation services to the child, which is difficult because our teachers don't have the training to do it. They don't have the capacity to do it. So again, what is expected in law and what is feasible in practice is sometimes a little bit blurry, but the moment there's a delictual claim, my feeling from what I've read in the last few cases are the schools are going to be held liable, and they are looking at ways to protect the children, and someone is responsible for not providing support to the child. And in that instance, it's going to be the department.
Thank you. Should we vet high level? Should we vet everyone? That's the question. The beauty is we're talking about a child here, a child in a school, and or maybe even beyond a school. The Children's Act, what does it say about children? It says, I mean, on vetting, it says employers, you will vet your employees. Doesn't say high level or low level. So usually on the SGB side, usually the employment, we will have our policies and so forth. So it's for us to strengthen our policies to say, who do we vet and the how part? And the vetting is actually a simple or a difficult process. You do have your high level vetting. If you have to go to the NSA, you don't have to go there. You've got your police clearance, the easy stuff. Police clearance that you can obtain in 24 hours or less. 2, you need to check with the SAES. That is, if we're talking educators, if it's an educator, you need to check with the SAES and again with the Department of Education. That's where your records are. As I said, first things first, at least your police clearance, that's the easiest. So as long as I'm to interact with children in a school, it is expected of me, the employer, to be diligent in what I do. Therefore, your vetting, I would say, vet everyone. 1. 2, Ruth, we've got sporting coaches in and out of school. Should we vet them? It's still the responsibility of the school. I said we interact. Actually, that is where a lot of things happen. Children are much more comfortable with their coaches, hence a lot of things happen between children and their coaches. Gerard will know. So it's extremely important that we vet everyone. And Ella, I don't know if we do have a special category for those now. I think, yeah. We do not have, as they are not teachers in the context of the SAES Act. But if they are teaching a PE, yes. So if they are teaching, that's the answer to an extent. If they are teaching physical education, then they need to be registered with the SAES in a special category. So it's important that we vet and ensure that everyone who interacts with our children is actually vetted. And when does vetting start? Should it be when they're working or not? No. The minute you intend, you say, I think I want to employ this person, then you should start. But I've always said to people, no, do it beforehand. When they apply, actually, you can say, please submit also. It doesn't mean I intend to hire you. I said, when you apply, there's nothing stopping you from saying, please submit also your police clearance, which, as I said, you get it in less than 24 hours. If you need guidance, we will guide you how, but it is easily accessible. So if I apply, I think it will be prudent actually in my policy to say, let's also attach this police clearance. It doesn't mean I'm going to hire you.
Thank you. So my question was, do I think bursaries are inherently human trafficking? And I think that's based on maybe the exploitative nature of those agreements. Look, as it stands, I think that's why we say it should align with the best interest of the child, and it shouldn't be serving the institutions. So even with the whole competition analysis, if institutions collude, it's for their own benefit. But the more options kids have, it takes away from that exploitative element. So is there room for improvement with bursaries and scholarship agreements? I think the aim should be to empower talented kids and to give them the best opportunities. So there is a lot of room to move away from it being this child who's being saved by the school and they need to do the most, but also in the best interest of these kids and to empower them. So personal thoughts, I think there's room for improvement, which is why it should be guided by constitutional principles and the best interest of the child. I don't know if that answers your question.
Thank you for your question. So my question was, what does it mean for a scholarship and bursary policy to be aligned with the school's admissions policy? So again, we have to remember that a school's admissions policy is, or rather a school's bursary and scholarship policy is an instrument of the admissions policy. So again, it has to be aligned because through the scholarship policy, the school admits, of course, and enrolls learners into the school. Again, another important thing is that the Schools Act, I believe it's Section 5, specifically states that the school may not discriminate against a learner unfairly. So again, if you're going to use criteria in your scholarship and bursary policy that is not aligned with your admissions policy, then it means then your admissions policy is infringing on the Schools Act. I'm just going to use a practical example here. If a school were ever to say that we will not, or rather our bursary and scholarship policy states that we will not accept applications from learners that come from school X and school Z because we have a gentleman's agreement. then that means again that you are unfairly discriminating, which means that your scholarship, or rather your admissions policy, is going against the Schools Act. So thank you. Thank you for your question.
If we can give a last round of applause to our panel. Thank you very much. Ladies and gents, we will be breaking for tea now. If I can ask that you be seated at past for our final session of the day.